Q. Alfie Bravo filed with the Regional Trial Court of Caloocan a complaint for a sum of money against Charlie Delta. The claim is for $1.5 million. The complaint alleges that Charlie borrowed the amount from Alfie and duly executed a promissory note as evidence of the loan. Charlie's office secretary, Esther, received the summons at Charlie's office. Charlie failed to file an answer within the required period, and Alfie moved to declare Charlie in default and to be allowed to present evidence ex parte. 10 days later, Charlie filed his verified answer, raising the defense of full payment with interest. 2006-2013 bar. Was there proper and valid service of summons on Charlie? A. No. There is no showing that earnest efforts were exerted to personally serve the summons on the defendant before substituted service was restored to. The service of summons was improper. In an action strictly in personam, like a complaint for a sum of money, personal service on the defendant is the preferred mode of service, that is, by handing a copy of the summons to the defendant in person. If defendant for excusable reasons cannot be served with summons within a reasonable period, then substituted service can be resorted to. Manotoc v. Court of Appeals, GR number 130974, August 16, 2006. Otherwise stated, it is only when the defendant cannot be served personally within a reasonable time that a substituted service may be made. Impossibility of prompt service should be shown by stating the efforts made to find the defendant personally and the fact that such efforts failed. This statement should be made and the proof of service. Galura v. Math Agro Corporation, August 14, 2009. Since there was no prior attempt to serve the summons in person, the substituted service to Charlie's secretary is invalid. B. If declared in default, what can Charlie do to obtain relief? A. If Charlie is declared in default, he has the following remedies to wit. A. He may, at any time after discovery of the default, but before judgment, file a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud, accident, mistake, or excusable neglect, and that he has a meritorious defense. B. If judgment has already been rendered, when he discovered the default, but before the same has become final and executory, he may file a motion for new trial under Section 1, letter A of Rule 37. C. If he discovered the default after the judgment has become final and executory, he may file a petition for relief under Section 2 of Rule 38. And D. He may also appeal from the judgment rendered against him as contrary to the evidence or to the law, even if no petition to set aside the order of default has been presented by him. B.D. Longspan Builders versus R.S. Ambelico Realty Development, Year 169919, September 2009. Note, there are additional remedies to address judgments by default. Motion for reconsideration, Rule 37, annulment of judgment, Rule 47, and petition for certiorari, Rule 65. Q. Juan sued Roberto for specific performance. Roberto knew that Juan was going to file the case, so he went out of town and temporarily stayed in another city to avoid service as summons. Juan engaged the service of Sheriff Matinik to serve the summons, but when the latter went to the residence of Roberto, he was told by the caretaker thereof that his employer no longer resides at the house. The caretaker is a high school graduate and is the godson of Roberto. Believing the caretaker's story to be true, Sheriff Matinik left a copy of the summons and complained with the caretaker. Was there a valid substituted service of summons? Discuss the requirements for a valid service of summons. 2016 bar. Answer: no. There was no valid substituted service of summons. In an activity strictly in personam, personal service on the defendant is the preferred mode of service, that is, by handling a copy of the summons to the defendant in person. If defendant for excusable reasons cannot be served with the summons within a reasonable period, then substituted service can be resorted to. While substituted service of summons is permitted, it is extraordinary in character and in derogation of the usual method of service. Hence, it must faithfully and strictly comply with the prescribed requirements and circumstances authorized by the rules. Compliance with the rules regarding the service of summons is as important as the issue of due process for the court to acquire jurisdiction. For the presumption of regularity in the performance of official duty to apply, the sheriff's return must show that serious efforts or attempts were exerted to personally serve the summons and that said efforts failed. These facts must be specifically narrated in the return. It must clearly show that the substituted service must be made in person, of suitable age and discretion, living in the dwelling or residence of defendant. Otherwise, the return is flawed and the presumption cannot be availed of. The Supreme Court laid down the requirements as follows. 1. Impossibility of prompt personal service, example, the party relying on substituted service, where the sheriff must show that defendant cannot be served promptly, where there is impossibility of prompt service within a reasonable time being so much time as is necessary under the circumstances for a reasonably prudent and diligent man to do, conveniently, what the contract or duty requires that should be done, having a regard for the rights and possibility of loss, if any, to the other party. Moreover, it must be indicated therein that the sheriff has made several attempts at personal service for at least 3 times on at least 2 different dates. Number 2. Specific details in the return, i.e. the sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. 3. Substituted service effected on a person of suitable age and discretion residing at defendant's house or residence, or on a competent person in charge of defendant's office or regular place of business. M. Imelda Manutok v. Court of Appeals. Q. Tristan filed a suit with the RTC of Pasay against Arthur King and or estate of Arthur King for a conveyance of a lot declared in the name of Arthur King under TCT number 1234. The complaint alleged that on account Arthur King's residence abroad up to the present and the uncertainty of whether he is still alive or dead, he or his estate may be served with summons by publication. Summons was published and nobody filed any responsive pleading within 60 days therefrom. Upon motion, defendants were declared in default and judgment was rendered declaring Tristan as the legal owner and ordering defendants to reconvey said lot to Tristan. Jojo, the court-designated administrator of Arthur King's estate, filed a petition for annulment of judgment before the CA, praying that the decision in favor of Tristan be declared null and void for lack of jurisdiction. He claims that the action filed by Tristan is an action in personam and that the court did not acquire jurisdiction over defendants Arthur King and or his estate. On the other hand, Tristan claims that the suit is an action in rem, or at least an action quasi in rem. Is the RTC judge correct in ordering service of summons by publication? Explain. 2016. Yes. The RTC judge is correct in ordering the service of summons by publication. An action for declaration of nullity of title and recovery of ownership of real property or reconveyance is not a real action, but it is an action in personam, for it binds a particular individual only, although it concerns the right to a tangible thing. Any judgment therein is binding only upon the parties properly impleaded. Heirs of Eugenio Lopez Sr. versus Enriquez, cited in Ermita Munoz versus Attorney Victoriano Yabut Jr. and Samuel Go Chan, DR number 142676, June 6, 2011. In an action in personam, jurisdiction over the person of the defendant is necessary for the court to validly try and decide the case. Jurisdiction over the person of a resident defendant who does not voluntarily appear in court can be acquired by personal service of summons as provided under Section 7, Rule 14 of the Rules of Court. If he cannot be personally served with summons within a reasonable time, substituted service may be made in accordance with Section 8 of said rule. Spouses Domingo and Belen et al. Versus Honorable Pablo Chavez et al. March 26, 2008. Under Section 14, Rule 14, Rules of Court, in any action where the defendant is designated as an unknown owner, or the like, or whatever his whereabouts are unknown, and cannot be ascertained by diligent inquiry, service may, by leave of court, be effected upon him by publication in a newspaper of general circulation, and in such places and for such time as the court may order. This rule applies to any action, whether in personam, in rem, or quasi in rem. Pedro T. Sanos Jr. versus P&OC Exploration Corporation, September 23, 2008. Clearly, since the action for reconveyance is an action in personam, the RTC judge is correct in ordering service of summons by publication. Alternative answer: no, the RTC judge is not correct in ordering service of summons by publication. It is well settled that in an action in personam, wherein the defendant is a non-resident who does not voluntarily submit himself to the authority of the court, personal service of summons within the state is essential to the acquisition of jurisdiction over her person. This method of service is possible if such defendant is physically present in the country. If he is not found therein, the court cannot acquire jurisdiction over his person, and therefore cannot validly try and decide the case against him. Spouses Domingo and Belen et al. Versus Honorable Pablo Chavez et al. Accordingly, the RTC judge is not correct in ordering service of summons by publication. Motions. Omnibus Motion Rule Q. Therese, alleging that she was a resident of Lapu-Lapu City, filed a complaint for damages against Atlanta Bank before the RDC of Lapu-Lapu City, following the dishonor of a check she drew in favor of Shirley against her current account, which she maintained in the bank's local branch. The bank filed a motion to dismiss the complaint on the ground that it failed to state a cause of action, but it was denied. It thus filed an answer. A. In the course of the trial, Therese admitted that she was a U.S. citizen residing in Los Angeles, California, and that she was temporarily billeted at the Pescado Hotel in Lapu-Lapu City, joining the bank to file another motion to dismiss, this time on the ground of improper venue, since Therese is not a resident of Lapu-Lapu. Therese opposed the motion citing the Omnibus Motion Rule on the motion. Answer. The bank's second motion to dismiss, which is grounded on improper venue, should be denied. The improper venue of an action is deemed waived by the bank's filing an earlier motion to dismiss without raising improper venue as an issue, and more so when the bank filed an answer without raising improper venue as an issue after its first motion to dismiss was denied. Under the Omnibus Motion Rule, Rule 15, Section 8, which governs the bank's motion to dismiss, such motion should include all objections then available. Otherwise, all objections not so included shall be deemed waived. B. Suppose Therese did not raise the Omnibus Motion Rule. Can the judge proceed to resolve the motion to dismiss? Explain. Answer. Yes. The judge can proceed to resolve the motion to dismiss because the ground raised therefore became known to the movant only during the trial, such that it was only then that the objection became available to him. C. Suppose the judge correctly denied the second motion to dismiss and rendered judgment in favor of Therese, ordering the bank to pay her $100,000 in damages plus legal interest. The judgment became final and executory in 2008. To date, Therese has not moved to execute the judgment. The bank is concerned that its liability will increase with a delay because of the interest on the judgment award. As counsel of the bank, what move should you take? 2010 Bar. A. As counsel of the bank, I shall recommend to the bank as judgment obligor, to make a tender of payment to the judgment obligee, and thereafter make a consignation of the amount due by filing an application therefor, placing the same at the disposal of the court which rendered the judgment. Articles 1256 and 1258. New Civil Code. Motions for Bill of Particulars. Q. When can a Bill of Particulars be availed of? What is the effect of non-compliance with the order of a Bill of Particulars 2003 bar? A. Before responding to a pleading, a party may move for a Bill of Particulars of any matter which is not averred with sufficient definiteness or particularity to enable him properly to prepare his responsive pleading. If the pleading is a reply, the motion must be filed within 10 days from service thereof. Section 1, Rule 12. If the order is not complied with, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. Section 4, Rule 12. Q. Within the period for filing responsive pleading, the defendant filed a motion for a Bill of Particulars that he set for hearing on a certain date. However, the defendant was surprised to find on the date set for hearing that the trial court had already denied the motion on the day of its filing, stating that the allegations of the complaint were sufficiently made. A. Did the judge gravely abuse his discretion in acting on the motion without waiting for the hearing set for the motion? Answer: no. The judge did not gravely abuse his discretion when he denied the motion for Bill of Particulars without waiting for the hearing set for the motion. Section 2, Rule 12 of the Rules of Court authorizes the court to either deny or grant said motion outright upon the clerk of court bringing such motion to the attention of the court. The motion may lack merit. B. If the judge grants the motion and orders the plaintiff to file and serve the Bill of Particulars, can the trial judge dismiss the case if the plaintiff does not comply with the order? 2008. Answer is yes. The trial judge can dismiss the case if the plaintiff failed to comply with the court's order to file and serve the needed Bill of Particulars. Section 4, Rule 12 of the Rules of Court authorizes the court to order the striking out of the pleading affected, hence the dismissal of the complaint. To the same end as the provision of Section 3, Rule 17 of the Rules when plaintiff fails to comply for no justifiable cause with any order of the court or with the rules. Res judicata. Q. What is res judicata in prison gray? What are the essential requirements or requisites of res judicata? 2000 and 2010 bar. Answer. Res judicata in prison gray is the criminal concept of double jeopardy, as res judicata is the doctrine of civil law, Trinidad versus Office of the Ombudsman. Described as res judicata in prison gray, the right against double jeopardy prohibits the prosecution of a person for a crime of which he has been previously acquitted or convicted. The purpose is to set the effects of the first prosecution forever at rest, assuring the accused that he shall not thereafter be subjected to the danger and anxiety of a second charge against him for the same offense. Joel B. Sayes versus Intermediate Appellate Court, DR 74989-90. The essential requisites of res judicata are: 1. The judgment or order rendered must be final. 2. The court rendering the same must have jurisdiction of the subject matter and of the parties. 3. It must be a judgment or order on the merits. And 4. There must be, between the two cases, identity of parties, identity of subject matter, and identity of causes of action. San Diego versus Cardona, GR 46655. Distinguished bar by prior judgment from conclusiveness of judgment, 1997 bar. A. Bar by prior judgment is the doctrine of res judicata which bars the second action when there is identity of parties, subject matter, and cause of action. Section 47, letter B, Rule 39. Conclusiveness of judgment precludes the relitigation of a particular issue in another action being with the same parties on a different cause of action. Section 47, letter C, Rule 39. Grounds. Q. Amorsolo, a Filipino citizen permanently residing in New York City, filed with the RTC of Lipa City a complaint for rescission of contract of sale of land against Brigido, a resident of Barangay San Miguel, Santo Tomas, Batangas. The subject property, located in Barangay Talisay, Lipa City, has an assessed value of 19,700. Appended to the complaint is Amorsolo's verification and certification of non-form shopping, executed in New York City, duly notarized by Mr. Joseph Brown, a notary public in the state of New York City. Brigido filed a motion to dismiss the complaint on the following grounds. A. The court cannot acquire jurisdiction over the person of Amorsolo because he is not a resident of the Philippines. Answer. The first ground raised lacks merit because jurisdiction over the person of a plaintiff is acquired by the court upon the filing of plaintiff's complaint therewith. Residency or citizenship is not a requirement for filing a complaint because plaintiff thereby submits to the jurisdiction of the court. Letter B. The RTC does not have jurisdiction over the subject matter of the action involving real property with an assessed value of 19,700. Exclusive and original jurisdiction is with the MTC, where the defendant resides. Answer. The second ground raised is also without merit, because the subject of the litigation, rescission of contract, is incapable of pecuniary estimation, the exclusive original jurisdiction to which is vested by law in the RTC. The nature of the action renders the assessed value of the land involved irrelevant. C. The verification and certification of non-form shopping are fatally defective because there is no accompanying certification issued by the Philippine Consulate in New York, authenticating that Mr. Brown is duly authorized to notarize the document. 2009. Answer. The third ground raised questioning the validity of the verification and certification of non-form shopping for lack of certification from the Philippine Consulate in New York, authenticating that Mr. Brown is duly authorized to notarize the document, is likewise without merit. The required certification alluded to pertains to official acts or records of official bodies, tribunals, and public officers, whether of the Philippines or of a foreign country. The requirement in Section 24, Rule 132 refers only to paragraph A of Section 29, which does not cover notarial documents. It is enough that the notary public who notarized the verification and certification of non-form shopping is clothed with authority to administer oath in the state or foreign country. Q. Mariano, through his attorney-in-fact Marcos, filed with the RTC of Baguio City a complaint for annulment of sale against Henry. Marcos and Henry both reside in Asin Road, Baguio City, while Mariano resides in Davao City. Henry filed a motion to dismiss the complaint on the ground of prematurity for failure to comply with the mandatory barangay conciliation. Resolve the motion with reasons 2009. A. The motion to dismiss should be denied because the parties in interest, Mariano and Henry, do not reside in the same city or municipality, or is the property subject of the controversy situated therein. The required conciliation or mediation before the proper barangay, as mandated by the local government code, governs only when the parties to the disputes reside in the same city or municipality, and if involving real property, as in this case, the property must be situated also in the same city or municipality. Q. AB, as mother and in her capacity as legal guardian of her legitimate minor son, CD, brought action for support against EF as father of CD and AB's lawfully wedded husband. EF filed his answer denying his paternity with counterclaim for damages. Subsequently, AB filed a manifestation in court that in view of the denial made by EF, it would be futile to pursue the case against EF. AB agreed to move for the dismissal of the complaint, subject to the condition that EF will withdraw his counterclaim for damages. AB and EF filed a joint motion to dismiss. The court dismissed the case with prejudice. Later on, Minor Sun City, represented by AB, filed another complaint for support against EF. EF filed a motion to dismiss on the ground of res judicata. Is res judicata a valid ground for dismissal of the second complaint? Explain your answer. 2000. Answer: no. Res judicata is not a defense in an action for support even if the first case was dismissed with prejudice on a joint motion to dismiss. The plaintiff's mother agreed to the dismissal of the complaint for support in view of the defendant's answer denying his paternity with counterclaim for damages. This was in the nature of a compromise of the right to support, which is prohibited by law. Article 2035. The Assist v. Court of Appeals, February 15, 1999. Q. A. A resident of Lingayen, Pangasinan, Sud X, a resident of San Fernando, La Union, in the RTC of Quezon City, for the collection of a debt of 1 million. X did not file a motion to dismiss for improper venue, but filed his answer raising therein improper venue as an affirmative defense. He also filed a counterclaim for 80,000 pesos against A for attorney's fees and expenses for litigation. X moved for a preliminary hearing on said affirmative defense. For his part, A filed a motion to dismiss the counterclaim for lack of jurisdiction. A. Rule on the affirmative defense of improper venue. Answer: there is improper venue. The case for a sum of money, which was filed in Quezon City as a personal action, it must be filed in the residence of either the plaintiff, which is in Pangasinan, or the defendant, which is in San Fernando, La Union, Section 2, Rule 4. The fact that it was not raised in a motion to dismiss does not matter, because the rule that if improper venue is not raised in a motion to dismiss, it is deemed waived, was removed from the 1997 Rules of Civil Procedure. The new rules provide that if no motion to dismiss has been filed, and if the grounds for dismissal may be pleaded as an affirmative defense in the answer. Section 6, Rule 16. B. Rule on the motion to dismiss the counterclaim on the ground of lack of jurisdiction over the subject matter, 1998. Answer: the motion to dismiss on the ground of lack of jurisdiction over the subject matter should be denied. The counterclaim for attorney's fees and expenses of litigation is compulsory counterclaim because it necessarily arose out of and is connected with the complaint. In an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. Section 7, Rule 6. Q. Ko Batong, a Taipan, filed a civil action for damages with the Regional Trial Court of Paranaque City against Jose Penduko, a news reporter of the Philippines Times, a newspaper of general circulation printed and published in Paranaque City. The complaint alleged, among others, that Jose Penduko wrote malicious and defamatory imputations against Ko Batong, that Ko Batong's business address is in Makati City, and that the libellous article was first printed and published in Paranaque City. The complaint prayed that Jose Penduko be held liable to pay 200,000 as moral damages, 150,000 as exemplary damages, and 50,000 as attorney's fees. Jose Penduko filed a motion to dismiss on the following grounds. The RTC is without jurisdiction because under the totality rule, the claim for damages in the amount of 350,000 pesos fall within the exclusive original jurisdiction of the Metropolitan Trial Court of Paranaque City. The venue is improperly laid because what the complaint alleged is Ko Batong's business address and not his residence address. Are the grounds invoked in the motion to dismiss improper? Letter A. The RTC is without jurisdiction because, under the totality rule, the claim for damages in the amount of 350,000 fall within the exclusive original jurisdiction of the Metropolitan Court of Paranaque City. Answer: no. The ground invoked in the motion to dismiss is not proper. Under Article 360 of the RPC, the civil action for damages in cases of written defamation may be filed separately in the regional trial court where the libellous article was printed and first published, regardless of the amount of damages being claimed. Letter B. The venue is improperly laid because what the complaint alleges Kobatong's business address and not his residence address. 2014. Answer: the venue is properly laid. Under the law, the venue for the civil action involving written defamation shall be the place where the defamatory article was printed and first published. Article 360 RPC. Since the defamatory article was printed and first published in Paranaque City, the venue of the action is properly laid. Hence, the dismissal of the complaint will only be proper if the complaint failed to allege the residence of the complaint or the place where the libellous article was printed and first published. Newcomb v. Tan, September 23, 2005. Q. X was driving the dump truck of Y along Catleya Street in Santa Maria, Bulacan. Due to his negligence, X hit and injured V, who was crossing the street. Lawyer L, who witnessed the incident, offered his legal services to V, who suffered physical injuries, including a fractured wrist bone, underwent surgery to screw a metal plate to his wrist bone. On complaint of V, a criminal case for reckless imprudence resulting in serious physical injuries was filed against X before the Municipal Trial Court of Santa Maria. Attorney L, the private prosecutor, did not preserve the filing of a separate civil action. V subsequently filed a complaint for damages against X and Y before the Regional Trial Court of Pangasinan in Urdaneta, where he resides. In his certification against forum shopping, V made no mention of the pendency of the criminal case in Santa Maria, 2010. Is V guilty of forum shopping? Answer: no. V is not guilty of forum shopping because the case, the Santa Maria Bulacan, is a criminal action filed in the name of the people of the Philippines, where civil liability arising from the crime is deemed also instituted therewith, whereas the case filed in Urdaneta, Pangasinan is a civil action for quasi-delict in the name of V and against both X and Y for all damages caused by X and Y to V, which may be beyond the jurisdiction of MTC. Hence, the test of forum shopping, which is res adjudicata or litis pendentia, do not obtain here. Moreover, substantive law, Articles 33 and CC and Section 3, Rule 111, expressly authorize the filing such action for damages entirely separate and distinct from the criminal action. Letter B. Instead of filing an answer, X and Y moved to dismiss the complaint for damages on the ground of litis pendentia, as the motion meritorious explained. Answer: no. The motion to dismiss based on alleged litis pendentia is without merit because there is no identity of parties and subject matter in the two cases. Besides, Article 3.3 of the Civil Code and Rule 111, Section 3 of the Rules of Criminal Procedure authorize the separate civil action for damages arising from physical injuries to proceed independently. Letter C. Suppose only X was named as defendant in the complaint for damages. May he move for the dismissal of the complaint for failure of V to implead Y as an indispensable party? Answer is no. X may not move for dismissal of the civil action for damages on the contention that Y is an indispensable party who should be impleaded. Y is not an indispensable party, but only a necessary party. Besides, non-joinder and misjoinder of parties is not a ground for dismissal of actions. Section 11, Rule 3. D. X moved for the suspension of the proceedings in the criminal case to await the decision in the civil case. For his part, Y moved for the suspension of the civil case to await the decision in the criminal case. Which of them is correct? Explain. Answer: neither of them is correct. Both substantive law, Article 3.3 and CC and procedural law, Section 3, Rule 111 provide for the two actions to proceed independently of each other. Therefore, no suspension of action is authorized. E. Attorney L offered in the criminal case his affidavit respecting what he witnessed during the incident. X lawyer wanted to cross-examine Attorney L, who, however, objected on the ground of lawyer-client privilege. Rule on the objection, 2010. The objection should be overruled. Lawyer-client privilege is not involved here. The subject on which the counsel would be examined has been made public in the affidavit he offered and thus no longer privileged, aside from the fact that it is in respect of what the counsel witnessed during the incident and not to the communication made by the client to him or the advice he gave thereon in his professional capacity. Remedies. Q. Mr. Avenger filed with Regional Trial Court a complaint against Ms. Bright for annulment of deed of sale and other documents. Ms. Bright filed a motion to dismiss the complaint on the ground of lack of cause of action. Mr. Avenger filed an opposition to the motion to dismiss, state and discuss the appropriate remedy or remedies under each of the following situations. A. If the RTC grants Ms. Bright's motion to dismiss and dismisses the complaint on the ground of lack of cause of action, what will be the remedy or remedies of Mr. Avenger? Answer. Mr. Avenger can choose any of the following remedies. 1. Mr. Avenger may file a motion for reconsideration. If denied, he could file an appeal to the Court of Appeals under Rule 41, since a dismissal based on lack of cause of action under Rule 33 is appealable. Number 2. Mr. Avenger may file a motion for reconsideration. If the same is denied, he could file a petition for certiorari under Rule 65, because a dismissal based on failure to state a cause of action is considered without prejudice and therefore an interlocutory order, which cannot be subject of an appeal under Rule 41. 3. Mr. Avenger may file a motion for reconsideration if the same is denied. He can simply refile the complaint because an order granting a motion to dismiss based on failure to state a cause of action is without prejudice to the filing of another complaint. Section 5, Rule 16. Number 4. Mr. Avenger may amend his complaint as a matter of right, since the motion to dismiss is not a responsive pleading. Irene R. Marcus Araneta v. Court of Appeals. B. If the RTC denies Ms. Bright's motion to dismiss, what will be her remedy or remedies? Ms. Bright may file a motion for reconsideration. If the same is denied, she could file a special civil action for certiorari under Rule 65. An order denying a motion to dismiss is interlocutory because it does not finally dispose of the case and in effect directs the case to proceed until final adjudication by the court. Hence, a special civil action on certiorari is the appropriate remedy. Section 1, Rule 41. Marmo v. Anakai. Number 2. Ms. Bright may file an answer without the balance of the period from the filing of his motion to dismiss, but not less than 5 days, and raise affirmative defenses therein. Section 4 and 6, Rule 16. Letter C. If the RTC denies Ms. Bright's motion to dismiss and further proceedings, including trial on the merits, are conducted until the RTC renders a decision in favor of Mr. Avenger, what will be the remedy or remedies of Ms. Bright, 2014? Ms. Bright may avail of the following remedies before the finality of the decision. 1. A motion for reconsideration, Section 1, Rule 37. Number 2. A motion for a new trial, Section 1, Rule 37. And 3. Appeal, Rules 40, 41, 42, 43, and 45. After the finality of the decision, Ms. Bright can avail of the following. 1. Petition for relief, Rule 38. Number 2. Annulment of judgment, Rule 47. And 3. Petition for certiorari, Rule 65. Dismissal of actions. Q. Ben sold a parcel of land to Dell with right to repurchase within 1 year. Ben remained in possession of the property. When Ben failed to repurchase the same, title was consolidated in favor of Dell. Despite demand, Ben refused to vacate the land, constraining Dell to file a complaint for unlawful detainer. In his defense, Ben averred that the case should be dismissed because Dell had never been in possession of the property. Is Ben correct? 2008. Answer: no, Ben is not correct. In an action for unlawful detainer, it is not required that the plaintiff be in prior physical possession of a land, subject of the action. In this action by the vendee arretrator against a vendor arretrator, who refused to vacate the property even after title has been consolidated in the vendee, the latter, in contemplation of law, steps into the shoes of the vendor and succeeds to his rights and interests. Pharma Industries versus Honorable Paharilaga, October 17, 1980. Maninang versus Court of Appeals, September 16, 1999. Pre-trial. Q. Upon termination of the pre-trial, the judge dictated the pre-trial order in the presence of the parties and their counsel, reciting what had transpired and defining 3 issues to be tried. A. If immediately upon receipt of his copy of the pre-trial order, plaintiff's counsel should move for its amendment to include a 4th triable issue, which he allegedly inadvertently failed to mention when the judge dictated the order, should the motion to amend be granted reasons? Answer: depending on the merit of the issue sought to be brought in by the amendment, the motion to amend may be granted upon due hearing. It is a policy of the rules of court that parties should be afforded reasonable opportunity to bring about a complete determination of the controversy between them, consistent with substantial justice. With this end in view, the amendment before trial may be granted to prevent manifest injustice. The matter is addressed to the sound and the judicious discretion of the trial court. Letter B. Suppose trial had already commenced and after the plaintiff's second witness had testified, the defendant counsel moves for the amendment of the pre-trial order to include a 5th triable issue, vital to his client's defense. Should the motion be granted or the objection of plaintiff's counsel? Reason: 2009. Answer: the motion may be denied since trial had already commenced and 2 witnesses for the plaintiff had already testified. Courts are required to issue pre-trial order after the pre-trial conference has been terminated and before trial begins, precisely because the reason for such order is to define the course of the action during the trial. Where trial had already commenced, more so, the adverse party had already presented witnesses. To allow an amendment would be unfair to the party who had already presented his witnesses. The amendment would simply render nugatory the reason for or purpose for the pre-trial order. Section 7, Rule 18 on pre-trial and civil action is explicit in allowing a modification of the pre-trial order before trial begins to prevent manifest injustice. Distinction between pre-trial in civil case and pre-trial in criminal case. Q. Give 3 distinctions between a pre-trial in a criminal case and a pre-trial in a civil case. 1997. Answer: 3 distinctions between a pre-trial in criminal case and a pre-trial in civil case are as follows. 1. The pre-trial in a criminal case is conducted only where the accused and counsel agree. Rule 118, Section 1. While the pre-trial in a civil case is mandatory. Section 1 of former Rule 20, Section 1 of new Rule 18. Number 2. The pre-trial in a criminal case does not consider the possibility of a compromise, which is one important aspect of the pre-trial in a civil case. Section 1 of former Rule 20, Section 2 of the new Rule 18. Number 3. In a criminal case, a pre-trial agreement is required to be reduced to writing and signed by the accused and his counsel. See Rule 1118, Section 4. While in a civil case, the agreement may be contained in the pre-trial order. Section 4 of former Rule 20, Section 7 of new Rule 78. Intervention. Q. What are the requisites for an intervention by a non-party in an action pending in court? 2000. The requisites for intervention are: A. Legal interest in the matter in controversy. B. Legal interest in the success of either of the parties, or C. legal interest against both, or D. so situated as to be adversely affected by distribution or other disposition of property in the custody of the court or of an officer thereof. Letter E. Intervention will not unduly delay or prejudice the adjudication of the rights of original parties. F. Intervenor's rights may not be fully protected in a separate proceeding. Acenas II versus Court of Appeals. August 29, 10, 1995. Modes of discovery. Q. Describe briefly at least 5 modes of discovery under the Rules of Court, 2000. Answer. 5 modes of discovery under the Rules of Court are: 1. Deposition, by leave of court after jurisdiction has been obtained over a defendant or over property which is the subject of the action, or without such leave, after an answer has been served. The testimony of any person, whether a party or not, may be taken, at the instance of any party, by deposition upon oral examination or written interrogatories. Section 1, Rule 23. Number 2. Interrogatories to parties, under the same conditions specified in Section 1 of Rule 23. Any party shall file and serve upon any adverse party written interrogatories regarding material and relevant facts to be answered by the party served. Section 1, Rule 25. Number 3. Admission by adverse party. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document, or of the truth, or of any material and relevant matter of fact. Section 1, Rule 26. Number 4. Production or inspection of documents or things. Upon motion of any party showing good cause, therefore, a court may order any party to produce and permit the inspection and copying or photographing of any designated documents, etc., or order any party to permit entry upon designated land or property for inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. Section 1, Rule 27. Number 5. Physical and mental examination of persons. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him to submit to a physical or mental examination by a physician. Section 1, Rule 28. Written interrogatories to adverse party. Q. An heir, oppositor, in a probate proceeding, filed a motion to remove the administrator on the grounds of neglect of duties as administrator and absence from the country. On his part, the heir or oppositor served written interrogatories to the administrator preparatory to presenting the latter as a witness. The administrator objected, insisting that the modes of discovery apply only to ordinary civil actions, not special proceedings. Rule on the matter, 2008. Answer. The administrator's contention that the modes of discovery apply only to ordinary civil action and not to special proceedings is not correct. Section 2, Rule 72 of the Rules of Court provides that, in the absence of special provisions, the rules provided for in ordinary civil actions shall be, as far as practicable, applicable in special proceedings. There is no provision to the contrary that would preclude the application of the modes of discovery, specifically interrogatories to parties under Rule 25 of the Rules to Probate Proceedings. Q. A tugboat owned by Speedy Port Service SPS sank in Manila Bay while helping tow another vessel, drowning 5 of the crew in the resulting shipwreck. At the Maritime Board inquiry, the 4 survivors testified. SPS engaged attorney Ellie to defend it against potential claims and to sue the company owing the other vessel for damages to the tug. Ellie obtained signed statements from the survivors. He also interviewed other persons, in some instances making memoranda. The heirs of the 5 victims filed an action for damages against SPS. Plaintiff's counsel sent written interrogatories to Ellie, asking whether statements of witnesses were obtained, if written copies were to be furnished, if oral, the exact provisions were to be set forth in detail. Ellie refused to comply, arguing that the documents and information asked are privileged communication. Is the contention tenable? Explain. Answer: yes. The contention of counsel for SPS is tenable, considering that he was acting in his professional capacity in bringing about the statement he obtained from witnesses and the memoranda he made. The notes, memoranda, and writings made by counsel in pursuance of his professional duty form part of his private and confidential files in the case handled by him, hence privileged. Air Philippines Corporation versus Pensville, December 13, 2007. Q. In an Admiralty case filed by A against Y Shipping Lines, whose principal offices are in Manila, in the RTC, Davao City, the court issued a Subpoena duces tecum, directing Y, the president of the shipping company, to appear and testify at the trial and to bring with him several documents. A. On what valid ground can Y refuse to comply with the Subpoena duces tecum? Answer: Y can refuse to comply with the Subpoena duces tecum on the ground that he resides more than 50, now 100 kilometers from the place where he is to testify. Section 9 of former Rule 23, Section 10 of new Rule 21. The witness can also refuse to comply with the Subpoena duces tecum on the ground that the documents are not relevant and there was no tender of fees for 1 day's attendance and the kilometrage allowed by the rules. B. How can A take the testimony of Y and present the documents as exhibits other than through the Subpoena from the RTC 1997 bar? A can take the testimony of Y and present the documents as exhibit by taking his deposition through oral examination or written interrogatories. Rule 24, new Rule 23. He may also file a motion for the production or inspection of documents. Rule 27. Q. A. Briefly explain the procedure in interrogatories to parties under Rule 25 and state the effect of failure to serve written interrogatories. Letter B. Briefly explain the procedure on admission by adverse party under Rule 26 and the effect of failure to file and serve the request. 2016. Answer to letter A. Procedure. 1. Any party desiring to elicit material and relevant facts from any adverse parties shall file and serve upon the latter written interrogatories to be answered by the party served, or if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf. Section 1, Rule 25, Rules of Court. Number 2. The interrogatories shall be answered fully in writing and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 days after service thereof, unless the court on motion and for good cause shown extends or shortens the time. Section 2, Rule 25, Rules of Court. Number 3. Objections to any interrogatories may be presented to the court within 10 days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early a time as it is practicable. Section 3, Rule 25. Number 4. Should a party fail to file and serve written interrogatories on an adverse party, he cannot compel the latter to give testimony in open court or to give deposition pending appeal, unless allowed by the court for good cause shown and to prevent failure of justice. Section 6, Rule 25, Rules of Court. Spouses Vicente Afulugencia and Leticia Afulugencia. February 5, 2014. Answer to letter B. Procedure. Number 1. At any time after issues have been joined, a party may file and serve upon any party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request, or of the truth of any material and relevant matter of fact set forth in the request. Copies of the documents shall be delivered with the request unless copies have been already furnished. Section 1, Rule 26, Rules of Court. Number 2. Each of the matters of which an admission is requested shall be deemed admitted unless, within the period designated in the request, which shall not be less than 15 days after service thereof, or within such further time as the court may allow on motion, the party to whom the request directed, files and serves upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested, or setting forth in detail the reasons why he cannot truthfully either admit or deny those matters. Number 3. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his sworn statement as contemplated in the preceding paragraph, and his compliance therewith shall be deferred until such obligations are resolved, which resolution shall be made as early as practicable. Section 2, Rule 26, Rules of Court. Number 4. Any admission made by a party pursuant to such request is for the purpose of the pending action only, and shall not constitute an admission by him for any other purpose, nor may the same be used against him in any other proceeding. Section 3, Rule 26, Rules of Court. Number 5. Unless otherwise allowed by the court for good cause shown, and to prevent a failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue, which are or ought to be within the personal knowledge of the latter, shall not be permitted to present evidence on such facts. Section 5, Rule 26, Rules of Court. Production or inspection of documents or things. Q. Continental Chemical Corporation (CCC) filed a complaint for a sum of money against Barstow Trading Corporation (BTC) for the latter's failure to pay for its purchases of industrial chemicals. In its answer, BTC contended that it refused to pay because CCC misrepresented that the products it sold belonged to a new line, when in fact they were identical with CCC's existing products. To substantiate its defense, BTC filed a motion to compel CCC to give a detailed list of the product's ingredients and chemical components, relying on the right to avail of the modes of discovery allowed under Rule 27. CCC objected, invoking confidentiality of the information sought by BTC. Resolved BTC's motion with reason, 2009. I will deny the motion. The ingredients and chemical components of CCC's products are trade secrets within the contemplation of the law. Trade secrets may not be the subject of compulsory disclosure by reason of their confidential and privileged character. Otherwise, CCC would eventually be exposed to unwarranted business competition with others who may imitate and mark the same kinds of products in violation of CCC's proprietary rights. Being privileged, the detailed list of ingredients and chemical components may not be the subject of mode of discovery under Rule 27, Section 1, which expressly makes privilege information an exception from its coverage. Air Philippines Corporation versus Penswell. Q. The plaintiff sued the defendant in the RTC to collect on a promissory note, the terms of which were stated in the complaint and a photocopy attached to the complaint as an annex. Before answering, the defendant filed a motion for an order directing the plaintiff to produce the original of the note so that the defendant could inspect it and verify signature and the handwritten entries of the dates and amounts. Letter A. Should the judge grant the defendant's motion for production and inspection of the original of the promissory note? Why? Answer: yes, because upon motion of any party showing good cause, the court in which the action is pending may order any party to produce and permit the inspection of designated documents. Rule 27. The defendant has the right to inspect and verify the original of the promissory note so that he could intelligently prepare his answer. Letter B. Assuming that an order for production and inspection was issued, but the plaintiff failed to comply with it, how should the defendant plead to the alleged execution of the note, 2002? Answer. The defendant may file a motion to dismiss the complaint because of the refusal of the plaintiff to obey the order of the court for the production and inspection of the promissory note. Section 3, letter C, Rule 29. Physical and mental examination of persons. Q. Ernie filed a petition for guardianship over the person and properties of his father, Ernesto. Upon receipt of the notice of hearing, Ernesto filed an opposition to the petition. Ernie, before the hearing of the petition, filed a motion to order Ernesto to submit himself for mental and physical examination, which the court granted. After Ernie's lawyer completed the presentation of evidence in support of the petition in the court's ruling on the formal offer of evidence, Ernesto's lawyer filed a demurrer to evidence. Ernie's lawyer objected on the ground that a demurrer to evidence is not proper in a special proceeding. If Ernesto defies the court's order directing him to submit to physical and mental examinations, can the court order his arrest? 2015. If the order for the conduct of physical and mental examination is issued as a mode of discovery and Ernesto defies the said order, the court cannot validly order his arrest. Section 3, letter D, Rule 29. Demurrer to evidence. Q. AEX, a Makati-bound paying passenger of PBU, a public utility bus, died instantly on board the bus on account of the fatal head wounds he sustained as a result of the strong impact of the collision between the bus and the dump truck that happened while the bus was traveling on EDSA towards Makati. The foregoing facts, among others, were duly established on evidence in chief by the plaintiff T.Y., sole heir of AX. In T.Y.'s action against the subject common carrier for breach of contract of carriage, after T.Y. had rested his case, the common carrier filed a demurrer to evidence, contending that plaintiff's evidence is insufficient because it did not show that defendant was negligent, and 2, that such negligence was the proximate cause of the collision. Should the court grant or deny defendant's demurrer to evidence? Reason, 2004. Answer, no. The court should not grant defendant's demurrer to evidence because the case is for breach of contract of carriage. Proof that the defendant was negligent and that such negligence was the proximate cause of the collision is not required. Articles 1170 and 2201, No Civil Code, Mendoza v. Philippine Airlines, GR L3676.